The court hands down judgment today in the case of the Queen on the application of AB and the Secretary of State for Justice. In this case also, the court has ordered that no one is to publish or reveal the name or address of the appellant or any information likely to lead to either his identification or that of members of his family. In December 2016, the appellant pleaded guilty to sexual offences and was remanded in custody at Feltham Young Offenders Institution. He was then 15 years old. Over the next 8 weeks, he was placed on single unlock, meaning that he could not leave his cell when any other detainees were out of their cells, apart from some time in 3-officer unlock, which involved 3 officers being present whenever he left his cell. He was placed on this regime initially for the protection of officers, as he had a recent history of assaulting officers, and later for his own safety, after attempts to integrate him with other detainees resulted in his provoking them with racist abuse and being subjected to threats. He received no education or training during this 8-week period. He had limited forms of social contact, including occasional table tennis matches with an officer. He was visited by the chaplain, mental health professionals, and social workers. He issued a claim for judicial review against the Secretary of State for Justice. His claim was successful in part. The High Court decided that the Secretary of State had failed to comply with the Young Offender Institution rules and had breached Article 8 of the European Convention on Human Rights. But the High Court did not accept that the appellant had suffered inhuman and degrading treatment in breach of Article 3 of the Convention. He appealed against that part of the decision to the Court of Appeal, which dismissed his appeal. He now appeals to the Supreme Court. 2 arguments are made on his behalf. First, that the solitary confinement of any person under 18 automatically violates Article 3 of the Convention. Or alternatively, that such treatment can only be regarded as compatible with Article 3 if there are exceptional circumstances which render the treatment strictly necessary. The Supreme Court unanimously dismisses the appeal. When questions arise in connection with Convention rights, the Human Rights Act requires domestic courts to take into account relevant judgments and decisions of the European Court of Human Rights. Where there is a clear and consistent line of relevant case law of the European Court, this court has held that domestic courts should follow it unless there are circumstances which justify a different approach. Following that approach, it is not the task of domestic courts to introduce substantial innovations into the European Court's case law. Parliament's purpose in enacting the Human Rights Act was to ensure that there is correspondence between the Convention rights enforced domestically and those available before the European Court, not to provide for rights which are not available before the European Court. On that basis, the Supreme Court's starting point in this appeal is the case law of the European Court. That case law demonstrates a consistent approach to the application of Article 3 in cases concerned with allegations of ill treatment, including those concerned with the solitary confinement of adult prisoners and with the ill treatment of detained children and young people. The European Court asks itself whether the ill treatment has attained the minimum level of severity which is necessary for Article 3 to apply. The minimum level is not fixed, but depends on all the circumstances of the case. A range of matters are relevant, including the age of the applicant and the duration, the purpose, and the effect of the treatment. The European Court has not adopted any rule that the solitary confinement of a person under 18 is automatically a violation of Article 3. Such a rule would be inconsistent with its fact-sensitive approach. It's not open to the Supreme Court to depart from the European Court's case law by creating such a rule itself. Contrary to the argument made on behalf of the appellant, a different approach is not required or justified in the light of general comments issued by the UN Committee on the Rights of the Child. Those comments are not binding even in respect of the meaning of the Convention on the Rights of the Child, and would not be treated by the European Court as determinative of a question whether any particular provision of the Human Rights Convention has been breached. The European Court has also not adopted any rule that the solitary confinement of a person under 18 will be compatible with Article 3 only if there are exceptional circumstances which make such treatment strictly necessary. It is not the function of the Supreme Court to anticipate what would be a significant development in the application of the Convention. The Supreme Court accordingly rejects both the legal argument made on behalf of the appellant and dismisses the appeal. The Court will now adjourn.